All right. Calling matter number 12, Sushant Gupta versus Lee Ann DeSalvo. I'll start with plaintiff's appearance first. Do we have an appearance from plaintiff?
Good morning, Your Honor. This is the plaintiff, Sushant Gupta.
Good morning.
Good morning. Thank you. So,
one moment. I need an appearance from defense, please.
Christopher Brainerd, Your Honor, on behalf of defendant DeSalvo.
All right. Okay, so we are here on two orders to show cause. First, we're here on an order to show cause regarding the court's exercise of its authority under CCP 128 to subject Mr. Gupta to a pre-filing order. And we're also here on an order to show cause regarding the purpose and legal basis for defendant's notice of sale of real property of Mr. Gupta filed on February 28th, 2025, and why that filing should not be stricken by the court. I'm going to give you both my oral tentatives on these issues. So first I'll address the order to show cause. And before we start with hearing arguments, I want to lay out the the procedures, because I know Mr. Gupta is pro per. So I'm going to allow both sides. You've been on the line. You hear how the attorneys do not speak over each other. You hear how I do give everybody a chance to be heard before I issue final orders. If you hear something that Mr. Brainerd is arguing, and Mr. Brainerd, I'll ask the same of you, if you hear something that the other side is arguing you want to respond to, write it down. The court will give you an opportunity to address it, okay? Don't interrupt each other. We proceed very orderly here. We allow each side to be heard. And so I do want to let you know that even after I issue my oral tentatives, I will allow you to be heard on what the court is intending to do. So first I'll address the order to show cause regarding the purpose and legal basis of defendant's notice of sale of real property. The court did review the declaration of Mr. Brainerd indicating that the notice of sale should not have been filed, and that filing, there was a request to withdraw or strike that notice of sale. Is that correct, Mr. Brainerd?
Yes, Your Honor. On the same day you issued the OSC on the 26th, over a month ago of March, I withdrew it directly. I before this already recognized that it was ineffectual, but I did file an application with the court seeking your signature to an order to issue a notice of sale, but you never signed it. It's a new area, and I erred on the side of notice, but I do admit my errata and request that and note that it's probably moot because I've withdrawn it, but if you need to strike it, I understand.
All right. The court will be striking the notice of sale. I know that it's a new area of law, Mr. Brainerd, but given the circumstances of this case, you may have noted that spawned a number of filings related to that notice of sale and confusion about its impact, and you can understand how the threat of losing your home might cause you to take urgent and ex parte actions as the person who might be subjected to the potential loss of their home. Do you understand? It's not an insignificant error.
I understand, Your Honor, and I would agree that with a reasonable person and a normal person, that could spurn a response, and maybe, but this individual, Mr. Gupta, was engaged in these vexatious tactics long before there was ever a notice on sale. He had already back in December filed petitions to remove judges from the bench and all these alter egos, always an imposter, just an imposter. impersonating all these different people and signing these declarations, and then claims he's got a disability at age 40, 39, 40, while he's berating and attacking, character assassinating, filing false reviews, destroys my client's business, destroyed my business, it's taken away with his lies about being my client on fine law. And, my thoughts are with a person like this, I will do my level best to have them sanctioned for being frivolous and destructive and malicious, and then I will do my level best to enforce it. And at the time that I filed that notice, Sushant Gupta, I had a lien on that property, a legal lien with the Orange County Sheriff's Department, and this guy's made this case about me and trying to put me on trial for putting the wrong address on the thing and maybe not getting a court order first. But I got a lien on that property, and I'm giving him notice now. I intend to try to sell that property to satisfy it and any other sanctions award I can get. This is not a good guy. This is not somebody who's playing by the rules. This guy is a criminal. And I remember Justice Chafee took an attorney who behaved similarly to this, and this guy is practicing law. I remember Justice Chafee sending him directly down into the jail for 2 days. Confinement, had him confined. You can issue a warrant on this guy if he wants to be insolent. And I just want to remind you respectfully, Justice Panuco, it's nice to have met you for the first time, second time, that you have a lot of power. And sometimes you'll have to exercise it. And this is one of those times, in my opinion. And I hope you do. And if he continues to engage in this type of defiance of your orders, I request you order a warrant and have him confined, because he can be I'll come right down there and stand before you. Okay? I promise you. You just say when. I'll come there today. And I had half a thought to do it, rather than that's his strategy to waste my time. But this guy will never appear in court. You cannot serve him. He is damaging my reputation. I want to ask you if I can have permission to have you issue a restraining order against him to prevent him from doing any further character assassination on me. Do I have to go to the family court and then chase this guy all over the state to get jurisdiction over him, and then have to go through alternate service and have him then withdraw electronic service and then backdate electronic service?
All right, Mr. Brainerd, I am noting this has been very difficult for both of you. And I'm wondering if there's anything that an agreement we can reach today that would relieve both of you. Can we reach an agreement to just end this case so that both of you can move on?
Well, what about he's not going to. You believe that.
I'll hear from you first. If there's a way out of this, which is just end this case today, end these proceedings, and both of you just stop litigating against each other. There's some value to that, right? Mr. Brainerd, I'll hear from you first, and then I'll hear from Mr. Gupta.
I would agree. There would be benefit. I don't want anything more to do with this guy. I don't want to be engaged in this never-ending war with this lunatic. I want him gone. I want him to stop posting pretending to be my client, posting false reviews on me, damaging my. Yes.
I don't have power to issue restraining orders, but I have the power to try to help you both reach a resolution that would help you move on with your lives in this case, in this civil case.
Your Honor, I just want to point out that at this moment, my client has a pending civil harassment restraining order against this person who's demonstrated complete inability to control himself.
Okay, I can't help with any civil restraining orders. What I can do is try to help with this case.
Until I get that, I don't believe anything I do or say will stop this gentleman from continuing to abuse process in this case and any other he can in any court of appeal, all the way to and I'm prepared to defend it against all the way to the Supreme Court if necessary. That's the type of person we're up against. He has utilized processes vexatiously in a way I couldn't even have imagined. All right,
I've heard from you, Mr. Brainerd, on the issue of the notice of sale. I do just want to admonish you that moving forward, your papers need to also be supported by law. You see what a filing like this, it might seem like a minor error to file a notice of sale, but I do want to make sure you understand why it's not unreasonable for someone to act expeditiously and ex parte when the threat of losing their home, when they don't understand the legal process. You are a lawyer. Mr. Gupta is not. I understand how frustrated you must be, how much frustrated your client must be, but we cannot have documents being filed with the court that are not supported by law, and the notice of sale was not supported by law, so the court will be striking that. I'll now hear from Mr. Gupta before I address the order to show cause regarding the pre-filing order that the court set the OSC on today. I want to hear from you, Mr. Gupta, if there is any way that the court can help resolve this case today, to walk away and just have you stop filing anything more, stop pursuing anything more against Mr. Brainerd, against his client. Is that something that you're willing to do if Mr. Brainerd and his client, can we all just walk away and move on with our lives? I see this is taking a toll emotionally, financially on both of you. Is there a world where you would just agree to just stop?
Your Honor, I did hire a limited counsel. First of all, good morning, and I thank you for striking his notice of sale. I did hire for a limited period. It's called a limited counsel, Mr. Ernie Calhoun. He did offer him some money to settle and to walk away. But he said, because he has filed a notice of sale, okay, he won the full money with interest. Okay, and Mr. Calhoun was just a limited counsel. Okay. Now, I would like to respond to what Mr. Brainerd has said to you. Mr. Brainerd has said to you that he should not have filed that notice of sale, and it's a new practice of law. But let me tell you, on his website and on his Craigslist ads, he states he's a specialist on the quiet title, in the real estate field. He's a specialist. Okay, so I would like to let the court know that he's lying on record. Okay, it is not a new area for him. He has posted like multiple ads on Craigslist regarding the real estate. I can show it to the court in my next exhibit or in my next motion. And he also called me lunatic, which I would like the court to consider and strike. And he did mention that he had a pending civil harassment restraining order against me. That civil harassment restraining order, he was fined in contempt. He served me by email. And in that restraining order, it is baseless. They have mentioned I was asking for $30,000. There is no record of that. Then it's also mentioned that I called Miss Leanne DeSalvo and told her that I know where she lives and I will go and get her. If I'm that kind of a person, why would I file a civil case against her? If I will go and get her physically, and I don't even know where she lives. It's false. And he's also mentioning that I have an alter ego, Raj Chauhan. Raj Chauhan is an individual person. Okay. He's not an alter ego. And regarding my disability, I did provide all the records, and that can be checked from the hospital, from the recovery center, and from the doctors. I provided their phone numbers. I cannot fabricate everything. Okay.
All right.
If I fabricate anything, please send me to the jail. Okay. There are no false reviews. Everything is real. And I'm not trying to damage his image. I have nothing because we did try to settle the case with him. This is the baseless case he has put. Okay. So we did try to settle. Now he did not back down back then. So now I'm not backing down. And then for the notice of sale, ma'am, he put a fake address of the sheriff, which is the Orange County Men's Jail. Not only that, he put a fake date on that notice of sale. He has recorded multiple liens, 2 in Los Angeles County, 1 in Santa Clara County. You can check it's on court's record. My property is in Orange County. He has been filing fraudulent proof of services. And he's using the court process to harass me and force me for an out-of-court settlement, which I'm not going to do. I'm not going to pay him because he's an attorney. I'm educated too. I have done masters of business. And this year, I'm going to enroll in like law school myself. I'm actually preparing for SAT. So I'm not going to pay him money for free. It's my hard-earned money.
All right.
And yeah.
Okay. Thank you, Mr. Gupta. I did want to address one issue. I did note, and I should have done this in the beginning, I did note you filed a declaration to disqualify me from this case on April 24th, 2025, and you filed a supplemental declaration on April 25th, 2025 to disqualify me. The court reviewed the declaration filed by you, Mr. Gupta, seeking the assigned judge's disqualification. I did want to just put on the record that I will be entering an order that the declaration was improperly e-filed and was not personally served on me as required. The court is verbally striking that statement, those two statements, pursuant to CCP, Code of Civil Procedure, Section 170.4, Subdivision B, because the statement on its face does not disclose in either of the declarations legal grounds for disqualification. A written order will follow this hearing today, and the parties will have 10 days from the written order to challenge the court's ruling pursuant to 170.3 Subdivision B. So I did want to acknowledge that I know you moved to disqualify me from this case, but it was not done properly and there's no legal basis for it. But again, the court is giving 10 days from the written order that I issue to challenge my ruling today, which is why we're proceeding, because I have not been properly, there's not been a proper motion to disqualify me filed. So having heard from you, Mr. Gupta, what I'm proposing, again, is, and I don't know that Mr. Brainerd will consider it either, but I'm trying to help the two of you move on. There's a lot of value from having to be subject to the stresses of litigation, and I'm not proposing that you pay Mr. Brainerd. I'm proposing, will either of you just walk away, just stop filing against cases, motions, things, starting new restraining order proceedings in other courts. I'll hear from you first, Mr. Gupta, if you'd consider just walking away from this. If the two of you will just agree, we can set another status conference to discuss a potential settlement in the case. And I want to talk about that before I discuss my proposed order on the pre-filing. But go ahead, I'll hear from you first, Mr. Gupta. I mean, Mr. Brainerd may not even consider it, but I don't even want to ask him if you're not willing to just walk away from this.
Your Honor, I would have done it absolutely, but because of Mr. Brainerd, I attempted suicide. I went to the recovery center. I was in the therapy for depression. I have taken medication for that. Okay. And I was not in my senses. It's only because of my friend, Raj Chauhan, I'm back in my senses. If I was not in my senses, he would have really sold my house and taken the money. Okay. And this is not the first time he has done this. He has done this with Diana Wallach, filed a fake restraining order against her, did not serve her. And then there was one more lady, Kamala Kassel. He also filed a restraining order against her as well. Whoever doesn't go by his way, he files a restraining order against them.
But what if he's agreeing to both of you? What if you just both agree to stop? Isn't there some value to you to just move on from this, Mr. Gupta?
Absolutely, Your Honor. But what about my time I wasted? I went to the recovery center, You
see, Your Honor,
that's not.
I went to the.
Your Honor,
I'll hear from you, Mr. Brainerd. I'll hear from you. I just want. All right, Mr. Gupta, I understand your position. I do want to just, again, we're here because of potential frivolous filings by you. The things you're describing to me are not actionable. What I'm talking to you about in this proceeding, what you're describing to me is not actionable in this proceeding. And so continuing to fight, continuing to file documents, that's not going to change what happened. What can change moving forward in your mental health is just ending this. There's some value to that. Would you agree to just, and again, I'm not putting Mr. Brainerd in a position, but.
I'm sorry to interrupt you. I object for just this much to say that yes, okay, to you, Justice Panucco, and your wisdom, I would say yes, okay? But I observe that this vexatious litigant sued and swore a death pledge against my client and now against me and will never let it go, apparently. Is incapable of letting it go. That's why it shocked my conscience. I have no choice. So if I were to do that, to think that he would stop, he, as he says openly, never. Okay. Thank you for hearing my objection, Your Honor. Respectfully. Thank you so much.
All right. Mr. Gupta,
can I say something?
Mr. Gupta, there's really nothing that will help, the value of just ending this and the sale, there's no value to you in that, to just have your mental health and your sanity and your stress levels, just ending all of the things that are going on and the restraining orders. What if Mr. Brainerd agreed to that? If you agree to stop pursuing things, stop posting things online, what if you got peace? Is there any value to that for you, Mr. Gupta?
It does have value, ma'am, but he has created a lot of problems for me. I had to drive at least 10 times.
I'm proposing that could all be resolved. I'm proposing something that would bring you peace. Again, I don't know if Mr. Brainerd would agree. It sounds he might be open to it if you are, but if you're not open to it, don't you want peace? Don't you want to have to stop coming to court?
I do want peace, Your Honor. Of course I want peace. I have wasted a lot of money, a lot of my peace on this. And I also want to tell him that I'm not a vexatious litigant. I'm not on a vexatious litigant list. I was never served an order of the vexatious litigant. And there is no signed order by the Judge Marky Wyndham. So I'm not a vexatious litigant. From last 7 months, he's making a fool of everyone of the court that I'm a vexatious litigant. I'm not a vexatious litigant.
Okay, I do want to. All right, I'll if you can hear from me now. I do want to clarify some things. There is an order issued by Judge Wyndham on October 14th, 2024, declaring you a vexatious litigant. So you are on the Judicial Council's vexatious litigant list. Now I want to address. I've given you an opportunity to see if we can resolve this issue. I want to note that we have a number of motions coming up. There's, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 motions coming up. 10 more times where I'm going to see the two of you. And if at any time you want to discuss just resolving this case, we can do that in the next 10 more times that I'm going to hear from you. But right now I'm going to give you my oral tentative regarding the pre-filing order. So the court finds that all future filings in this action or on behalf of, by or on behalf of plaintiff Sushant Gupta are subject to a pre-filing review by this court before they will go on the court's docket. This does not include any appeal-related documents. This court can't control what you file on appeal. Appeal-related documents are to be filed following all applicable rules and procedures regarding location, manner, and deadlines for filing. Moving forward, my order is that plaintiff is to lodge in person any and all non-appeal-related documents in this action. The documents proposed for filing must be lodged in the clerk's office located on the second floor of the Spring Street Courthouse. The court will review all documents lodged with the clerk. The court will determine whether each of these in-person filed documents comply with the California Rules of Court, the California Code of Civil Procedure, and the local rules of the Los Angeles Superior Court. The court will approve or deny each lodged document for filing, and the court will mail notice of whether a filing by plaintiff that was submitted to the second floor clerk's office is approved or denied within 14 days of lodging with the clerk's office. So all of your documents moving forward, Mr. Gupta, will need to be lodged in person with the clerk's office. If you file a motion, anything you intend to file, it needs to be done in person. Given the volume of filings, since the date I set this order to show cause hearing back in March, there have been over 70 filings by you in this case. Some of them just declarations, some of them not tied to any notice motion, and that is just unacceptable. I understand that you are a pro per litigant, but it does not relieve you of the obligations to look up the rules of court, look up the rules of procedure, look up the Los Angeles Superior Court rules every time before you file a document. And because you have been unable to do that, the court will be doing that before letting any document that you file go on the docket. And I want to explain to you why the court has to implement this pre-filing order. Again, over 70 documents have been filed by you in less than 30 days. Over 70 documents. A lot of them, as I said, not tied to anything. And the court has 5,000 cases. The reason why people file hearing and motions and get hearing dates is so that every one of those 5,000 cases has a fair opportunity to be heard. Everyone wants their cases to be heard quickly. Everyone has urgent issues. But the way you get your issues heard by the court are to file noticed motions. And that is why the rules have to be followed, because we can't have you jumping ahead of everyone who is following the rules, who's getting a hearing date, who's filing their motion, who's complying with the deadlines. And it's not just about the other parties and the other cases that the court has to hear. It's also about due process. If Mr. Brainerd files a motion, he has to do it with enough notice to you to file an opposition so that you can be heard and so that the court reviews both sides, motion, opposition, reply. The court reviews the law, the evidence, and can prepare a tentative and informed ruling. And those are the reasons why we have to follow the rules of procedure, because the court can't just drop everything every time you file something and try to see what it is that you're filing and what it is related to and whether or not there's something the court can do about it. The court is not on the computer all day looking at the docket in your case. As you can see today, I had 30 matters on calendar. I have to prepare for all of them. And so for that reason, I will hear from you, but that is my tentative ruling. I'm going to subject you to a pre-filing order. And again, only things that are regularly noticed and that comply with all of the rules will be going on the court's docket. And I will give you approval or denial 14 days after you lodge your documents in the clerk's office. So I'll hear from you before I enter my tentative ruling.
Okay, ma'am. I would not like I would like to withdraw from this tentative ruling because I just figured it out that I'm not on the vexatious litigant list. You can look it up. Okay. I never received the signed order. Okay. The VL100, which was filed with the court on October 14th, 2024, didn't have any attorney name or the moving party's name. And that there's a non-existent party which has been entered in the VL100 form, which is Kristen Leherov or Kristen Leheri. The party against whom the case was filed was Kristen Leahy, not Kristen Leherov or Kristen Leheri. So there is a non-existent party on VL100, and I filed a separate motion for that for a June 4th hearing. Okay. I'm not on a vexatious litigant list, okay? So I shouldn't be, and ma'am, the only reason I filed so many motions because there's so much of like fraudulent activity by Mr. Brainerd. He's misusing his law license. Okay. He has filed a fake notice of sale, then fake writs. You haven't said a single word to him. Fake writs, duplicative liens, 2 liens in the Orange County Clerk Recorder, duplicative liens. He called my real estate agent to pay him the money multiple times, threatening him, you know. And ma'am, you are asking me to come over to the court. I don't like filing any motions in the court. I have to. I've been forced to. This will be an additional burden for me. I'm still going through the therapy and medication. I cannot drive all the way to the court from Fullerton, ma'am. It's too far. It's traffic. I have to pay for the parking. I have to pay for the gas, and I'm not making any money right now. So I respectfully address to you, and I will, if he cancels the lien on my property, if Mr. Baynard cancels the lien on my property, you know, I will walk away. I can give him that opportunity, but I'm not going to pay him any money.
All right. Well, the court has heard from all the parties. Mr. Gupta, it sounds like you have a motion on calendar on June 4th. At that time, the court will review whether you've been properly put on the vexatious litigant list or what that issue is about. I don't have that in front of me right now, and that's why we file motions, because the court obviously is not prepared to address that issue today, what I was prepared for, and what you all filed declarations on, and what the court had time to review, given the 30 other matters on calendar today, was the OSC. At that time, on June 4th, we will give proper time and for Mr. Brainard to respond. That's why we file motions, so that Mr. Brainard can respond to whether or not whatever your motion is about, Mr. Brainard's going to be able to respond. That's why the motions have to be properly noticed. And I understand your...
I haven't received this motion.
Correct. And so if it's not properly served or filed or properly noticed, that is grounds for it to be stricken. Again, non-compliance with the rules.
I just filed yesterday.
Okay. So you have to make sure it's served within the deadline so that Mr. Brainard can file objections or file his opposition, whatever that needs to be done. If I will again admonish you, if the rules of court are not being complied with, that is...
Your Honor, doesn't he have to for this motion that he's contemplating, he has to comply with the order that you're issuing today, right?
This one was before. It sounds like it looks like it was filed before I entered the order. But moving forward after today, Mr. Gupta, I just want to alert you that all of your electronic filings will be rejected. You need to, and that is going to cause you to make sure that every time you file a document, it is based in law and following the code of procedure. It is not just a filing that you think is necessary. You need to do research. There's a local law library. There are legal clinics. There are legal aid organizations that can help you make sure you're complying with the rules. But if you file a regularly noticed motion, you will be heard. You will have the opportunity to be heard as long as it complies with the rules of court. So after today, all of your filings that you try to file electronically will be rejected. You must come to the second floor clerk's office to file anything. That will be the order of the court. I will hear from you one last time, but I'm mindful of the time. There are several other parties with their motions waiting to be called. This is the last time I'll be able to hear from you. Go ahead.
Okay, sure. Ma'am, I would like to say that you have you have been extremely harsh on me. I have been following all the guidelines, all the rules of the court. This motion, which I filed yesterday, has given Mr. Brainard 16 days to review and reply. This has been filed. All of my motions, all of my papers have been filed in the court with the due process and filing all the, following all the CCP and all the regulations. It's not my wish, not to follow any of the court rules or the regulations. As I told you before, I do not have money right now. It's too much of it's around 50 miles from here to go to the court from Fullerton, parking, gas. It's very, very harsh of you to put that restriction on me to go over there and file for every motion in the Windows 2nd in Spring Street Courthouse. And you haven't said a single word to Mr. Brainard. He has done massive fraud. He's doing it again and again every day, misusing his law license. You haven't put any restriction on him. You haven't said anything to him. This is not fair, ma'am.
I actually did. Mr. Brainard was admonished about his notice of sale, admonished that he needs to file documents that are supported by law and the rules of court and procedure and notice. He was admonished, and I did strike his notice of sale. So there have been consequences to Mr. Brainard. He was admonished. I did have the whole first part of this hearing was spent with just Mr. Brainard and his conduct as well. And I have admonished him that if he files documents that are not supported by the law, those will also be treated the same as I have been, to the same scrutiny that I have been subjecting yours to, Mr. Gupta. However, you have refused to comply with the court's admonishments. And so I will have to log off. I have several other matters I need to get to. I've given you more time than I've given any other matter today, despite having 30 cases on calendar today. So the court will be entering its tentative ruling. After today, there will be no further e-filings. You have to file everything in person on the second floor in compliance with the rules of court. So there needs to be a proof of service attached to every document that you file so that I know that it's been served on Mr. Brainard. And Mr. Brainard, given this, this 14-day approval period, you should factor that into any motions that you file. There's got to be sufficient time in advance that if Mr. Gupta has oppositions, his oppositions will need to be filed on the second floor. And so he'll need to have enough time to get review by the court. So add those 14 days to your notice period. Okay?
Okay, one last thing.
Yes?
Yes.
Can I do it by mail instead?
It has to be in person, Mr. Gupta. If you are complying with the rules of court, the court may consider removing some of those restrictions and making it mail. But for now, it has to be in person. Okay?
Okay.
All right. Thank you both for your time and helpful arguments.
One last thing. What about the lien on my property?
I can address that. You have to file a formal motion to address those issues. The court only had two things on calendar. 2 orders to show cause, okay. And that's what we're addressing today. I'll see you both again on May 12th, and on that day we're going to be addressing the motion to set aside or vacate the judgment. That is the issue and the only issue that is on calendar on May 12th, so I'll see you then.
Thank you, and take care.
Thank you both.